That is my lord. Vaccine mentioned item number 7.
Yes.
I'm appearing on behalf of my senior father, Semi Council for the SCB.
Press item
Item 7.
item 7. In item 7.
Yes, my lord.
Let it remain. I have to make some submission. Let it remain in the list.
Okay. Wait for some time there.
My lord, I beg to mention item number 20, last item.
Yes. What do you want?
My lord, conducting counsel Mr. O Modi for the respondent having some health problem, so that he cannot appear today. The matter may be listed up after summer vacation.
Have you informed the other side?
Yes, my lord. On 22 July. Matter may be fixed on 22 July.
Mr.
A Bonia.
Land Council, some ministers, the conducting council for the respondent, Mr. Orin Modi, has some health problem. Therefore, he prays for adjournment of the matter and to be listed on
22 July.
22.
22.
Election petition is there.
Okay. After 22,
23rd, let's say.
23rd.
Lordship.
Okay.
May it please your lordship.
To which Mr.
I put a petitioner. I'm appearing on behalf of N Pada, Lordship.
Land Council appearing on behalf of Mr. N. Pada, Land Council for the petitioner has no objection.
I have been instructed that this matter may be taken up on 20 July.
22,
20.
20.
My lord,
20
No,
also
election matters
lost.
are there.
My lord, on
20 cannot
20
be.
July, our council for the respondents having fixed matter on Pasigat, so that's why.
Okay, we'll set after 3 months, 3 weeks. Okay. After 3 weeks.
Much obliged.
Item number 1.
May I please start? In this revision petition, my lord, issue involved is order 23
The revision petition.
revision.
Yes.
My lord, if your lordship
Are you in this
permit, my lord.
case? Are you in this case?
Sorry, my lord, I am actually traveling to Aizawl, my lord. I had to make mention because of connectivity, my lord. I could not make mention item number 8, my lord, at the consent of the other side. I am appearing on behalf of the petitioner in this case, my lord.
Okay.
My lord, may I play this matter taken after vacation, my lord?
What do you want here?
My lord, it be
What
taken
is your
after vacation.
submission?
My lord, my submission is
After
the
vacation?
Yes, my lord.
My lord, they are repeatedly taking time, my lord, after obtaining the interim order.
Okay.
It is
Who-
more than 4 times. Not
Lord, I
only
have
once.
conveyed
Understand the
it to my
difficulty,
learned.
but I
Could have
understand
informed,
that-
could have informed the council for the other
Yes.
side yesterday.
Yes, I
or this morning.
No,
Lord,
my
I had
lord, yesterday
I
at
had
night he has
conveyed
sent
by
a
message.
WhatsApp
I had
message.
conveyed 2 weeks back, my lord, that I have a scheduled matter fixed in Aizawl on 1st, my lord. I personally met my learned friend, my lord. I had conveyed him.
Mr. R. Dubey, Land Council for the petitioner.
My lord, they are repeatedly taking time. Short date may be given just after vacation, my lord. I understand the difficulty, but problem is that they are repeatedly taking time.
Appearing through
And lordship,
video conferencing, The praise for adjournment of the matter to be listed. When you said
My lord,
after, I will say after
on
vacation.
20,
It's not possible on 20 election petition.
then my lord 21.
21,
21,
22, I have difficulty. Can it be on 23rd, my lord?
Okay.
Lordship, dear, we received the CD on
Mr. S.K. Deori, Land Council. Oh, sorry. To which Mr. Lloyd Lana PP and Mr. S.K. Deori, Land Council appearing on behalf of the respondent has no objection. As prayed for, command list is. Okay, raise objection. However, However, considering that Mr. R. Dubey, learning counsel for the petitioner, is out of station, the matter stand adjourned, list is matter after vacation. Okay.
Lordship, update CD may be called for Lordship, since we received the CD on 20.
On which date the updated case study will be produced by the land PP. Okay.
23rd.
My lord, the interim order needs to be continued, my lord.
23rd.
Yes, yes. My lord, the interim order needs to be continued, my lord.
Okay, the interim order pass earlier shall continue till next
I'm
day.
deeply obliged. I'm deeply obliged.
Updated case study may be
Called for.
applied.
May I please?
Yes.
Here in this case, my lord, the issue involved is with regard to withdrawal of suit, my lord, with liberty to file a press. Under order 23, rule 1, sub-rule 1 and sub-rule 3 of CPC. So basically what happened, on 2/6/2025, this respondent, he filed a title suit. List of dates, my lord. June 2025, my lord. The
Hmm.
title suit was filed by title suit number 2 of 2025 before the learned junior division at Namsai, wherein, my lord, the suit was valued at 7,40,000. Basically, in the suit, this respondent / plaintiff was claiming certain right over a plot of land, which is located at Deoville at Namsai. So in that case, we participated, and then on 25 September 2025, we have filed a written statement. This is brief fact, my lord.
Where?
Brief fact.
Brief fact.
Brief fact.
Where it is?
That, my lord, will find at page 80.
Page
Written statement is at page 80.
18.
80. And their title suit, my lord, will find at page 16. These are not issue, my lord.
No.
So
what-
just
Page 80. Oh, this is
these
what?
are the background.
Page 80 is what?
Page 80 is the written statement that we have filed, the petitioner
You have filed.
that was filed.
That
Basically, my lord, I am coming into the
The-
issue.
they filed title suit.
They have filed title suit number 2 of
You have filed
2025.
written statement.
We have filed a written statement. In the written statement, we have clearly raised the issue of maintainability, saying that the suit is undervalued, properly not valued, and then the necessary party is not implemented. Thereafter, my lord, on same day, 25 September 2025, we have also filed one IA, that is petition number 153 of 2025 for rejection of plant. That is also on 25 September 2025, my lord.
You filed a written statement containing that the suit is undervalued.
Undervalued and suit is not maintainable as necessary party. The title holder of the suit land is not being implemented in the case.
Necessary party.
Not implemented.
Okay.
So thereafter, on the same day when we have filed a written statement on 25th September 2025, we have filed another petition under Order 7, Rule 11
Hmm.
for rejection of plant. And thereafter, my lord, that petition number 153 of 25 that was heard on 3rd March 2026. That is, my lord, page 137. Herein after all the orders are important, my lord. Kindly come to page 137.
Hmm.
May I read, my lord?
Yes.
Plaintiff is present along with her learned counsel, Ms. So-and-so. Dependent is present. The learned counsel, Mrs. So-and-so, for a dependent is absent. The instant case is filed under Order 7 Rule 11A and B, read with Section 151 of CPC for rejection of plaint by the petitioner dependent. That we have filed, my lord. It is stated that the plaint is filed without proper valuation of the suit. It is also stated that the suit is not maintainable in this form for want of pecuniary jurisdiction, hence filed for rejecting the suit. Per contra, the opposite party plaintiff has filed the written objection denying all the contention raised in the petition. It is stated further that the plaintiff categorically mentioned and valued the property of suit at rupees 7,40,000. Kindly, this may be taken note of, my lord. As I have earlier also said, suit is valued at 7,40,000. Hence, it is stated that the plaint in its present form is maintainable in this court and therefore free to dismiss the instant petition. Considering the pleading of both the parties, I have given my thoughtful consideration to the issue. It is settled position of law that while rejecting the plaint under Order 7 Rule 11A, the court has to consider only the amendments made in the plaint. From the perusal of the plaint in its entirety, this court is of the considered opinion that the plaint disclosed the cause of action as the plaintiff has disclosed the tribal issues regarding the true ownership of the land described in the schedule. From the careful perusal of the plaint, it also revealed that the matter in controversy is related to half biga of land situated at Dioville, Namsai. From the averments in the plaint itself, it appears that the said suit land consists of one RCC building having 8 numbers of room, which is let out on rent. It further appears that the building is constructed for the purpose of commercial activities and the tenants therein are running shop. On careful perusal of the para 3 of the plaint, which states that the suit land was purchased at the rate of rupees 7,40,000. But the plaintiff has failed to specifically mention the accurate value of the suit land. Further, on perusal of the Annexure 6 of the plaint, it appears that the suit land consists of permanent RCC building, which will be having a value of more than rupees 7,40,000. Therefore, it appears that the plaintiff has undervalued the suit property in the plaint. This was the finding, my lord.
This is in IA filed by you.
Yes, my lord.
Okay.
Petition number 153 of 25. Therefore, now, direction, my lord. The plaintiff is required to properly value the suit property. This court deems it fit to give an opportunity to the plaintiff for making necessary amendment in the plaint, showing the proper valuation of the suit. The plaintiff is directed to take steps within a period of 14 days from today. Furnish a copy of this order to both the parties. So, the learned Junior Division Namsai, my lord, found that in fact the suit property was not properly valued. So accordingly, an opportunity was given to the plaintiff to amend the plaint by properly valuing the suit property, my lord. Thereafter, my lord, instead of filing any amendment application, what this respondent has done, he filed one miss case, number 2 of 2026 on 2/4/2026, 2nd April 2026, my lord. That, my lord, will find at page 146, my lord. There comes the problem, my lord. 146,
146
146
is order.
is order. On the same day that application it was filed for withdrawal of the suit, but my lord may kindly take a note of, with liberty to file a fresh. So that application that was mentioned, it was filed on 2nd April without issuing notice, my lord. It was heard and allowed. May I read the order, my lord? Case record is put up on filing miss case numbers 2 of 2026 under Order 23 Rule 1 of CPC, praying for withdrawal of the title suit number 2 of 2020 with a liberty to file a suit before the appropriate court. Peruse the petition and heard the learned counsel for the petitioner, Mr. So-and-so. It is submitted that the subject matter of the suit exceeds the pecuniary jurisdiction of this court. Considering the grounds shown in the petition, I am of the view that the petitioner has shown sufficient cause to withdraw the suit. Accordingly, the petition is allowed. In view of the aforesaid, the title suit number so-and-so disposes withdraw. So basically, my lord, why I am agree with this order, my lord? Because when I have entered afference and put my written statement and contesting the suit, the Honorable Apex Court has held, my lord, that had it been in a case of application for withdrawal simpliciter, my lord, it is not necessary to hear the other party. But when it is for withdrawal of the suit with a liberty to file a phrase on the same cause of action, my lord, then other party has to be heard, my lord. So,
Will issue
that-
notice?
my lord, I have interim prayer, my lord.
Pardon,
So-
Mr. K. Tama, Learned Counsel for the petitioner. Staff, huh? WS. This petition filed under Article 227 of the Constitution of India, read with Section 151 of the Civil Procedure Code 1908, is directed against the order dated 2/4/2026. 2/4/2026. This is the impugn order.
Impugn order, my lord.
What is your prayer? Let us see.
Kindly come to page, my lord.
Prayer for stay of this or
Another suit was filed, my lord. Taking advantage of this order, my lord.
Hmm.
Taking advantage of this withdrawal order, my lord.
Hmm.
What this respondent has done, he filed subsequent another suit at before the learned senior division Teju, my lord.
okay.
Wherein, my lord, even the parties which we have objected that necessary party was not implemented,
Hmm.
she was implemented, which is not permissible under the law. For that, I have two citations, my lord.
Okay, just a minute. Huh? Okay, directed against the proceeding initiated by the
Civil Judge Senior Division Teju.
just a minute. Huh? Your prayer is against this impugn order only, and then just a minute. Huh? Where is that? Where is the impugn order page?
Page, my lord, 146, my lord.
46, and then order dated, huh? 2/4/2026, passed by the Learned Civil Judge Junior Division, Namsai, in Miss J, case number 02/2026,
Entitled
under Order 23, Rule 1. Order Roman 23, huh? Rule 1 of the CPC. Whereby while allowing the plaintiff respondent to withdraw the title suit number 02/2025, granted liberty to file a suit before the appropriate court. Stop. Para. It is submit. The petitioner has also prayed for an interim. No, it is submitted that after taking advantage of the liberty granted, the respondent has filed what? Title suit,
Title suit 5 of 2026,
5 of 2026 before
the learned civil judge senior
The-
division at Teju.
Nara Court of Civil Justice Senior Division,
Teju, my lord.
Teju,
Wherein, my lord, new party was also added. That is not permissible.
okay. Wherein the new party
New party, my lord,
has been impleaded
implemented.
and what,
And that is not permissible as per the law, my lord.
which is not permissible as per the law. Stop. The Land Council for the petitioner submits that the petitioner has already filed written statement in the title suit wherein he has specifically contending that the suit is undervalued and the necessary party was has not been impleaded. Stop. This sentence, the earlier sentence would come in the later.
My lord.
Okay, I'll correct it. How we're taking advantage of the liberty granted, huh? Earlier that would, that would come here, taking advantage of the liberty granted has filed a suit before. That sentence will come here. Huh? That is suit before the Court of Civil Judge Senior Division, wherein the new party has been impleaded and also substantially improved the pleadings. Stop. Issue notice returnable by 4 weeks. Stop. The petitioner shall take steps for service of notice upon the respondent by speed post as well as by user process within a week from today. Stop. Para. List is matter after 4 weeks. And call for the record. Call for the trial court record. Stop. List is matter after 4 weeks. Stop. Para. In the meantime, just a minute. The petitioner has also prayed for interim or interim
For suspending, my lord,
or
the
the
impugned order dated 2/4/2025, 2026.
for interim order for suspension of the proceeding in title suit number 5, 2026,
Pending before the learned
pending before the Court of Civil Judge Senior Division.
Teju, my lord.
Mm. No, interim order. Okay, the issue notice in the for the interim prayer also. In the interim prayer also. Stop. In the meantime, until the next date, next returnable date, the further proceeding in the title suit number 5, 2025,
2026.
2026 pending before the Court of Civil Judge Senior Division shall remain state. Okay, till next date only.
My lord,
Okay.
highly obliged.
Item number 2.
May I please, my lord?
Yes.
My lord, this CRPC's file challenging the legality and validity of impugned so-called notice issued by the Arunachal Pradesh FX Customary Court. Before I brief the fact of the case, Lordship, I take to page number 18, my lord. Page number 18 is a impugn show cause notice. Page number 18, annexure 1, my lord.
Yes.
May I read out, my lord?
Hmm.
First show cause notice issues for Nile as per Nisi customary laws and practice. To Sri Navam Naku and others members, President of New Delhi, Sangdu Pota, so and so, that undersigned officers receive a written appeal on 26/2026, filed by Sri Tar James and family members, son of so and so, permanent resident of Dulane village under Sangdu Pota Circle, Pavumpare, Arunachal Pradesh, so and so, against the order dated 22nd May 2026, passed by the Inter-Village Territorial Customary Court of Sangdu Pota Circle, a case in between Sri Tar James and family members of Barses, Sri Navam Naku and other members, the resident of so and so, for land disputes at Taik Putung to paddy field of Sri Murang Papung, Tarajuli area under Sangdu Pota Circle. Therefore, the instant effects customary court has taken the cognizance of the appeal and ordered that its 22nd May 2026 shall be inoperative till next date.
Hmm.
Therefore, you are directed to attend the customary nyale fixed on 2nd July 2026 before the instant effects customary court of Arunachal Pradesh. That is office Upper Dobum Village, time 8 AM, to place your justification and adduce the evidence by bringing all the witnesses and evidence. Otherwise, the undersigned customary judge shall proceed ex parte and ex parte order or judgment against you according to Arunachal Pradesh Civil Courts Act. In this regard, undersigned will preside the customary court and following person are appointed as a customary judge, namely so and so, so and so. My lord, this appeal, which should not be jurisdiction,
So where is the disputed land located?
Sangdu Pota Circle at Sangdu Pota Circle under Pavumpare district, my lord.
So who lodged complaint?
Complaint is launched by one Sri Tar James, who is a respondent number 3 and 4, Tar James and his father. My lord, decision was
The initial complaint.
yes, they are the complainant. My lord, the complainant initially complainant was petitioner Navam Naku and others. Petition number 1, 2, 3, because they are the chairman, secretary, and vice chairman of the Village Development Committee of Indrajuli Village.
And that is why I'm asking, who initially lodged the complaint leading to
Petitioner-
leading to the
Yes, my
decision of the case by
Yes,
the
madam.
inter-village territorial customary?
yes, my lord, petitioner. Present petitioner
Petitioner.
has launched complaint.
Lodged before whom? Which
Inter-Village
authority?
Customary Court.
Inter-village, why not village authority?
Well, initially, inter-village decision was already taken place since 2011 and 12, my lord.
No. Yeah, was it settled by the village authority first?
Village
It is
authority has already
straight away
settled.
by the inter-village,
Village authority has already settled, my lord,
where?
in favor of the petitioners.
Where?
It's 2011 and 12, my lord.
Where?
So this page number, my lord, page number 35 is the executive magistrate order being passed by the ABC, ESC Balijan since 2012, my lord. My lord, may come to page number 38, my lord. 38, my lord, last paragraph, just this is operative portion, my lord. Page number 38, my lord.
Hmm.
In view of the above, many cases pending and entangled between Tar Tagyo. Tar Tagyo is here respondent number 3, my lord.
No, this is decided by executive magistrate.
Yes, my lord, based on the after Blaze Blaze authority has submitted the report before the ESC.
Okay, where is the initial decision?
My lord, initial decision was not,
Decision of the village authority.
that was not in written, my lord, because 2011-12, that was not in written. So verbally, there was settlement. This present respondent number 3 and 4 should not encroach the community land of Indrajuli village, my lord, which is belong to the petitioners, my lord. So, my lord, the question is now the validity of the law is that once
No, let us say, because step by,
yes,
if you said that it was decided by the village authority,
village authority, initially 2011 and 12, my lord.
11 and 12.
So that was.
Then before the inter-village territorial customary court, it was an appeal.
Yes, my lord. So
Where is that appeal?
appeal, my lord, written
filed
complaint is
appeal?
filed. Yes, page number, my lord, page number 19, my lord.
19?
Complaint, my lord, complaint against the petitioner, my lord. Sorry, respondent number 3 and 4.
19?
Page number 19 is a complaint, my lord. May I read out, my lord? Page number 19, my lord, annexure number 2, my lord.
It's a complaint only.
Yes, Because after settlement, my lord, this respondent number 3 and 4, they are repeatedly encroaching the community land of the Indurjuli, my lord. And even
This
they
was
have set
also
up-
this was also before addition of Deputy Commissioner.
Yes. After Deputy Commissioner, my lord, so Deputy Commissioner ADC,
What you have stated, let us see,
yes, my lord.
because this is supposed to be the appeal.
Yes, supposed to be the appeal, my lord, because time and again, the respondent number 3 and 4, they are encroaching the community land of Indurjuli village. And also by clearance
If you,
of jungle.
if you says that it was already decided, could have filed for execution.
My lord, that during that time, Arunachal Pradesh civil courts.
No, no, no,
was
this
not-
time, this is 26 only,
Yes, this is 26.
because the decision was there,
Yes, my lord.
2011-12.
Yes, my lord.
According to you, it is under your possession. The
Yes.
authority has already decided in your favor,
Yes, my lord.
the village authority, and then it was affirmed by the ADC.
Yes,
It is in your favor.
yes, my lord.
Then it should not have been in the form of complaint.
So after this complaint, my lord, ADC Balijan again forward back to Circle Officer Sangdupota, my lord.
Hmm?
Then Sangdupota, after this complaint, my lord. So, my
No,
lord,
this complaint is
this
regarding what?
complaint made to ADC Balijan, and after that ADC Balijan has sent back. the
What you
matter-
said here, that is important,
Yes, my lord.
because it was decided by the inter-village territory only, not by the village
Just
authority.
I read, my lord.
Hmm,
The
please.
complaint which launched before
Yes,
ADC Balijan. A complaint against Sri Tar James and family members, Dulane village under Sangdupata circle for illegal trespass at community land of Indurjuli. With reference to above stated subject, we'd like to inform you, your good office, that in the month of February 2023, Tar James and his family members of village Dulane under Sangdupata circle is starting the clearance of jungle for June cultivation near boundary area of their paddy field. Actually, the portion of land, the clearance of jungle is under the preserve or protection community land of the village individually since from the ancestral settlement of village. However, in the same time during jungle clearance by Sri Tar James and family, the work has been stopped by the villager of Indurjuli, sole owner of the said land, but they already destroy or clearance large quantity of area. On yesterday, 7 March 2026, around 2:30 PM, the fire broke up and starting from their location, which is already stopped.
No, this is only complaint. Hmm.
Yes, this is complaint, my lord, because matter has already settled earlier. So time and again, this complainant has encroached the land and by clearance of jungle and setting fire, my lord.
So the same person is claiming it should not have been, because had it been some other person, complaint of course lies, but then if you think that the same person against the decision made in 2011 and 12, if same person claims again, then it should be execution
My lord,
or a
After-
violation for violation.
my lord, after this complaint, ADC Balijan has returned back the matter to Circle Officer Sangdupota. And the Sangdupota Circle has issued, my lord, issued direction to the Gaambura. That is page number, my lord, page number 25, my lord. May I read out, my lord? Forwarding of land dispute case in between Sri Tar James and Navam Naku and party. With reference to the above mentioned subject, I am forwarding here with all the relevant document related to the above mentioned case. Further, you are hereby directed to amicable settle the case within village authority level, and after settlement of the case, detailed report is to be submitted.
It's
to
gone
the
back to
undersigned-
AFR. It's in the year 2026.
This is
Okay.
2020. After complaint launched, my lord, after complaint has been made. So thereafter, sir, this Gaambura has issued notice, my lord, circular.
And he's also asking to undersigned of it. To detailed report is to be submitted to the undersigned again.
After settlement, my lord.
After settlement, see, it's going back to AFR.
So my lord, again, page number 26 is the circular which issues by the Gaambura to both the parties, petitioner and respondent, my lord. Page number 26, my lord. So they have issues circular and
Okay.
meeting was fixed on 22nd May 2026, my lord.
Mm,
So after
it's a decision.
long decision, there was a settlement,
This was by the customary
inter-village customary court, my lord.
inter-village customary. Why inter-village customary court? Not by the village authority.
My lord, village authority, it was settled in the year 2011 and 12, my lord.
Hmm?
So after arrival finding the which decision being made by.
This is according to you,
Yes,
because this is a complaint, not a continuation of 2011 and 12.
yes,
This
my
is
lord.
not a continuation.
This is complaint was made, not continuation, but my lord, after settlement of the village authorities, the present case now continues that, my lord, the aggrieved parties should approach to the civil court, my lord, after decision being made by the inter-blazed customary court, my lord, as per provision, my lord.
Whole procedure. There is a problem with regards to the jurisdiction. Now this is
My lord,
inter-village.
my lord, just I'll
And above that, this is what, this is the apex customary.
affects customary court. My lord, there is no such provision in Arunachal Pradesh Civil Courts Act after decision being taken by the inter-blazed customary court. So FX court has
But
no
then you see,
jurisdiction, my lord.
this was not appeal, but then in your case also the inter-village territorial appeal, this is appellate authority, inter-village.
Yes, we have made
But
appeal
then-
before the
But then
inter-blazed.
this was, according to you, or as per the document, it is a mere complaint of encroachment that has been taken up by the inter-village territorial customary, who is otherwise the appellate authority again.
My lord, we as a blazer, we appeal before the inter-blazed territorial customary court, my lord.
No. This was, you see, you lodged complaint before the ADC only. ADC endorsed it to CO. CO issued, and then the inter-village territorial customer. This also doesn't have probably
Yes.
the jurisdiction.
So now,
And then this apex court,
FX court, my lord, the Arunachal Pradesh Civil Courts Act,
See-
they have no jurisdiction.
this is, no, so he filed appeal. Where is his complaint?
Complaint
or
copy is not.
appeal,
for this,
appeal.
my
Where
lord.
it is
Only
appeal?
We have issued so much notice from the FX
No,
customary court.
where is his appeal? Have you annexed?
No, we have not been punished, my lord, so far. We were directed to appear tomorrow, my lord. That is 2nd July 2026, my lord.
Hmm.
Lordship, I'll check
So
to the
court has
Arunachal
no
Pradesh
authority.
Civil Courts Act provision, my
For
lord.
the authority, it appears as no authority. One after another, higher authorities are there.
My lord, in section 15, my lord, Arunachal
Mhm.
Pradesh Civil Courts Act, there is a provision, once the decision being made in the inter-blazed territorial or FX customary court, that aggrieved party should go to the civil court, my lord. That is the provision. May I read out the lordship page number, section 15, my lord. Lordship,
Yes, that
but
is
I think
there.
Section 15 of Arunachal Pradesh Civil Courts Act 2022 amended, my lord.
Hmm.
Lordship, second page, subsection Roman 3, my lord.
Hmm.
After fourth provision to subsection 3 of section 15, the
Hmm?
following subsection shall be inserted.
No? Which one?
Section 15, my lord, section 15,
Amendment,
amended 2022.
amendment of subsection 3
Yes, my lord,
of section 15.
of section 15, my lord.
Okay, then,
So may I read on, my lord?
which one?
Here is the Roman 3, my lord, the Roman 3, and then subsection 4, it's mentioned
Okay,
subsection, inserted subsection.
yes. Hmm.
An appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territorial customary court or FX customary court by whatever name court.
So the inter-village customary court and the apex customary court is in the same level.
Same level, my lord. So, my lord, just I read out, my lord. Which shall settle the case as per local traditional customary laws under the provision of section 40 of the Assam Frontier Administrative Justice Regulation 1945. Provided that an appeal against the order of the inter-village territorial customary court or FX customary court shall lie before the court of civil judge junior division, the court of civil judge senior division, the court of additional district judge, or the court of district judge, as the case may be, as per their territorial and
Yes.
pecuniary jurisdiction.
Yes, that is there.
My lord, my contention is that this appellant, the respondent number two-
What I could find is this doesn't have, because the appeal should have been there, because the inter-village territorial customary court itself is a appellate court.
yes,
And
my
then
lord.
against that appeal, it should have been gone to the civil judge.
My lord, that is my contention.
Civil
my lord.
judge,
That
but
is
then-
my submission.
But then,
Because decision already made by the inter-village territorial.
No,
So,
yours,
agreed party-
yours also, see, you have lodged a simple complaint
yes,
against-
that is
against the
there, my lord.
respondent for encroachment. But then that was straight away decided by the inter-village territorial customary, which
Yes.
doesn't, which is otherwise appellate authority
Yes, my
under the customary.
But my lord, my submission is that, my lord, my humble submission, that is decision which already taken in the year 2011 and 12.
No, it's,
So
that
thereafter-
is what I'm saying. I'm
Yes.
trying to find out,
Yes,
but
ma'am.
then you could not also satisfy.
Yes.
This is mere complaint. It's not a continuation of earlier decision of
That is there,
2011 and 12.
That is there, ma'am.
It's a mere complaint for against the respondent for encroachment over your land,
Yes, my lord, that is.
which according to you claim that you have not said also that it was decided by the court. You only said that he has encroached.
It was,
This is mere complaint.
my lord, it was decided.
Why it should have been there, it should be decided by the territorial, inter-village territorial customary court straight away, because inter-village territorial court, it doesn't have the, you see, original jurisdiction. It is, it is this inter-village customary court or the apex customary court as the,
Appellate authority.
are appellate authority only.
Yes, my lord.
So yours is also decided by the appellate authority.
So that, therefore, my lord, I.
But then in any case, but this apex court doesn't have the power of
Jurisdiction.
jurisdiction.
So that's my prayer. ma'am.
There is a problem in your case, the decision in your favor also, and then of course the present one also.
That is
Uh,
there, my lord. My lord, in my
Well-
case, since years back, 2012, settlement was made, and thereafter that.
See,
let's-
it was not the continuation. I understand,
Complaint is not continuation, my lord. I
not
admit.
continuation.
Yes, man. I admit it.
Hmm. We'll,
So, my lord, this
anyway,
apex
what
court-
we'll do, we'll issue notice,
So, my lord, I have an interim prayer, my lord.
Mr. And Rama, learned counsel for the petitioner. Yes, anything to, yes. You have made as a respondent,
Yes, one, yeah, performer.
pro forma. Who, okay.
My lord, may I, my lord, there's a little error in here. They have made the judge a party in it. Judge cannot be made a party.
They are self-proclamation, self-proclaim as a FX customary court. Whether no any authority has authorized them as a FX customary court. My lord, in Arunachal Pradesh, we have 26 major tribes and more than 100 sub-tribes. But none of the major tribe and sub-tribe has authorized them to be the FX customary court, my lord.
26 including which? If you ask you to count 26, there is no 26 tribe.
My lord,
Yes.
they are self-proclamation to be the FX customary
So
court.
see, the
And the different, this,
one above one other authority is coming up. We do not know. We need to settle, I think.
yes, my lord.
Mm.
So this is law point of view, my lord. This has to be settled, my lord.
Above intervillage. And then this apex, the authority involved in apex consists of which Gamburas and head Gamburas of which village?
Yeah, my lord, this head Gambura of
Same village.
no, my lord, this FX customary court, this is from Karsingsa, my lord, Banadeva. And he himself.
And then
is a
what
president
about
of
the-
all Arunachal Pradesh Gambura Association.
Okay, this, what about the inter-village territorial customary court, the case which decided in your
Yes.
favor, consists of village, or the
Different-
Gamburas of which
Gam-
village?
That is, there is different Gambura was to participate in that process. my lord.
Different Gambura of different village?
Different village, my lord. The entire circle from Sangrupata circle, my lord.
Hmm.
One Navam Kama and then Tana Tagum is from Havia village. Tok Bado is from Basarnelo. And Navam
Hmm.
Tukia is from Indrajuli village. So five GB was appointed as a panel of that Korean.
It says that it's a apex customary code of Arunachal. That means the highest authority.
Highest authority, my
So
lord.
this is a
So-
supreme
They are
authority.
abusing the process of law, my lord. Completely misuse of the law, my lord. In the name of Arunachal Pradesh Civil Courts Act, my lord.
Problem. So everybody is coming up. Is claiming to be authority. Law has not been able to convince the properly.
And my lord,
But why you have, but then whatever may be, but the decision is made by the Gamburas, why you have implemented them as a respondent party?
my lord, they have to reply before the honorable court that whether he was legally authorized by the any competent authority or by the law department that he can maybe acted as a presiding judge of the FX customary
But
court.
the law says whatever name called. whatever name called,
Yes.
has not specifically mentioned you will be the authority for this. Law also doesn't say. Okay, also had Ms. Wang, Learned Government Advocate, appearing on behalf of the state respondent number 1. Start. Huh? Nakku. How many are, who is the Gamburas?
Respondent number 2, my lord.
2.
Yes, ma'am.
And then the
Issue so.
3? Who is
Three-
the
three-
main
three-
private respondent is 3 and 4.
3 and 4, my lord. Son and father who repeatedly encroach the community land of individual. 3 and 4 is private respondent.
Hmm.
And my lord, interestingly, my lord, it seems that.
Probably this respondent number 2, you may have to drop
Yes.
this Gambura. Let us see.
Yes.
Okay. This. The present application under Article 227 of the Constitution of India. Challenges the order dated. Where is the
My lord, show cause notice dated 32/6, page number
challenge? The
18.
so called notice. It's not only so called notice.
Not only so cause notice, stay has been already made.
There is a stay.
Yes.
This is order also.
Order, my lord.
So but it says so in the name of so called notice.
Yes.
So called notice stroke order dated 22/6.
22/6,
2026 issued by the Apex Customary Court of Arunachal Pradesh, whereby while directing the whereby the presiding head JB presiding customary judge of the Apex Customary Court of Arunachal Pradesh, while issuing so-called notice directing the petitioner to attend the customary NILE NYILEY on 2/7/2026 as also order that this is appeal. Okay. Order that the order dated 22/5/2026 passed by the
Intervillage territorial customary.
Intervillage
Territorial customary court. Sangdupata, sir.
Territorial Customary Court of Sangdupata Circle to remain inoperative till the next date. Stop. The grievance of the petitioner is that the earlier in the year 2000 by an order dated 15/10/2012, the land in question has been declared as belong to the petitioner by the Executive Magistrate cum Extra Assistant Commissioner UPIA. While the petitioner was under peaceful possession of the said land, the respondent encroached the land of the petitioner, leading to filing of complaint before the ADC, who then has endorsed the same to the circle officer. Circle officer Sangdu Putta, who thereafter has endorsed, thereupon has endorsed, then thereafter has endorsed the matter to the GB, GB. It's endorsed is also to President GB.
Yes, my lord, option.
Lot of problem to the Gambaras for settlement staff. Accordingly, the Inter-Village Territorial Customary Court of Sangdu Pota Circle, after hearing the parties, has settled the matter and decided the land in question in favor of the petitioner. However, by the impugn SOCOS stroke order dated 22/6/2026, the respondent number 2 claiming to be the apex customary court of Arunachal Pradesh has directed the petitioner to appear in connection with the land dispute on 2nd July 2026, and in the meantime, the order dated passed by the Inter-Village Territorial Customary Court on 22 May 2026, which was affirmed by the circle officer Sangdu Pota by order dated 9/6/2026 has been made inoperative till the next date. Staff after issue notice returnable by 4 weeks. Staff ampara. The petitioner shall take steps for service of notice. Since Miss one more learned government advocate accepted notice on behalf of the respondent number 1, no formal notice is required to be issued. Staff, the petitioner shall take steps for service of notice upon the respondent number, rest of the respondents by a speed post as well as by usual process within a week from today. Staff, call for the record, relevant record. Stop, huh? Para, since the petitioner has also made interim prayer. No, since the interim prayer has also been made, comma, notice on the prayer for interim relief is also made returnable by the next date, huh? Stop, para. In the meantime, there shall be a stay of the operation of the impugn notice stroke order dated 22/6/2026 passed by the Apex Customary Court of Arunachal Pradesh. Stop. Okay. The parties shall also maintain status quo over the disputed land based on that. Okay.
My lord, till then, the show cause notice may be still.
That is state.
My lord.
Operation of the so-called notice come order state. But then you should also,
Yes,
since
we
they
are
are
always
disputing,
maintain.
maintain the status quo.
This
Okay.
person is destructing the everything, my lord, in the jungle clearance and all. We are never being, we are preserving the natural flora and fauna, my lord, and the natural environment, my lord.
Settle it.
Yes.
Give some part.
Highly up.
He is claiming since then. So he cannot live just that way. He will go to the higher authority also.
My lord,
Give
we
some
have
part
portion
to
of
this
land, my lord.
individual because
We
you are in a community, you are community,
Yes.
clan, you are owning, and then give some part of it to him. He is also cultivating somewhere nearby.
We have already given, my lord, some portion of land.
So decide it once for all.
Beyond that, he is encroaching day by day, my lord. That is the issue.
Because the court will not be able to decide those things because you are the person who have been there, and you know that since when he is there, and they also know that because they are expecting because they have been looking it as their own property since then, since long. So unless some some portion is parted,
Yes.
to of course not to satisfy, but at least to settle, get settled. Let his mental be settled down there.
Yes.
So no more encroachment. That is enough. No, let him also think that way. So that is the only solution. Law will not be able to decide the jungle area because the court will not be visiting.
Correct.
Okay.
Much.
Item number 3.
My lord, this is a regular bail application, my lord. So I'm praying for, my lord, calling of the scanned copy of the DCR,
Okay.
my lord.
Okay. Call for the.
Is TCR, Your Lordship.
Okay. Mr. JTK, Land Counsel for the petitioner. Also had Ms. Jenny, Learned additional PP for the state. Para, this is application filed under section 483 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for grant of bail to the accused who has been arrested in connection with the Chimpu police station case number 24/2024 under section 21B stroke 27 capital A stroke 29 of the Narcotic Drugs and Psychotropic Substances Act 1985. Case already charged sheeted?
Charge sheet.
Okay, now pending before the court of the special judge NDPS UPR. In case number 33 stroke 2026. Stop, umpire. Miss. Okay. Now call for the scanned copy of the trial court record. It is submitted that the case has already been charged sheeted and now pending before the court of special judge NDPS UPR. Huh? The earlier one. Stop. Huh? Call for the scanned copy of the case trial court record. Stop. Huh? This test matter. When?
On 27, Your Lordship,
27.
July.
So
Because on the first week, we have fixed many cases,
Okay. Okay.
Grateful.
Item number 4.
May I please, man.
Yes.
My lord, as per observation of this honorable court day before yesterday, I have filed additional affidavit for adding the victim as party.
Including the, okay, victim was not included.
Yes, Your Honor.
Now, where is the settlement? Where is the FIR? Let us just see once. What was the FIR? Let us just recall.
FIR is in page number 21.
Complaint, page 21. And then the two-person name.
21 is type of here. May I read?
Yes.
FIR against one Sri Pema Gadi and Arjun Gadi alias Tagyong Gadi. So it is to inform you that two person, namely Pema Gadi and Tagyong Gadi, on 17/9/2021 illegally trespassed at my Biswakarma Pendal at around 2:30 a.m. situated at New Delhi Village 1, PS New Delhi, destroyed Biswakarma idol in order to promote enmity between different groups on ground of religion and breach peace and harmony. Moreover, though has made deliberately maliciously act intended to outrage religion's feeling by insulting the religion's belief. That, sir, at the same time, the two persons have mercilessly beaten
Okay.
in
So they have been beaten.
Yeah.
So let us see. Now, thereafter, case charge sheeted.
Yeah, case charge sheeted and now is the stage of CC on it.
Or charge not yet framed.
The charge frame, the trial is going on at stage of CC, consideration of charge.
No.
The charge is not framed yet. It is
Okay.
fixed on 23 of this month.
23.
23. My lord, all the sections are compatible, but one of the section 295 is non-compatible, which is because of that. The party has
What is the maximum punishment?
maximum punishment extend up to 7 years. That's 325.
Is there many minimum also?
No, minimum is not there.
Not there. Okay.
Yes. 7 years, but 325 is compatible, but 295 is non-compatible, which is 2 years punishment only. 295 is destroying and defacing of religion's idol. Actual fact of the case is that on the incident, there was Biswakarma Puja celebration at. Because of that, there was loud sound come from the Biswakarma Pendal. At the night, at 2:30 a.m., the alleged accused person went to Biswakarma Pendal to ask the minimize the loud sound. So because of that, there was an argument between alleged accused person and the victim.
Okay. So, any objection?
No, Lordship, because they have already.
They have settled.
Yes, Lordship.
Now all parties are there.
Yes, Lordship.
And then no need to aggravate.
No, Lordship.
Heard Mr.
El Kagong.
Learned counsel for the petitioner. Also heard Ms. El Hage. Learned additional PP for the state. Stop para. This application under section 528 for Bharatiya Nagrik Suraksha Sanhita 2023 has been filed jointly filed by the accused and the informant, the accused informant stroke victim in where is the yes case number you have written? Where have you mentioned the police station case? FIR 61/2021. Praying for setting aside and quashing of the GR case number. Where have you mentioned Lord Council, where have you mentioned the case
Page
number
number
which you
one.
wanted? Huh?
Page number 1,
Page
page number 1.
1,
Yes.
where is GR case?
Category questioning and setting aside of charge sheet number such and such, GR number,
Page number?
page number 1 of the main petition. Yeah.
Page number 1,
Yes. GR number 860.
where,
Three.
Page
Eh?
number 1
Yes.
of petition?
Main petition. Yes.
An application under sections of whether for setting a question of
No,
where?
no, above.
Where are you reading? An application
No, above.
for
Above the Chief Justice, Your Honor, category, Your Honor.
above Chief Justice?
Yes,
Where?
category, questioning and setting aside of.
Category.
Yes,
In the category?
yes.
Where is the prayer? There is no prayer for quashing.
Yeah, prayer is there, Your Honor. Prayer.
Where? So,
Page number 9, Your Honor.
okay. Nirjali Police Station, FIR. No, you are. Where? Where? GR case, praying for GR case, charge sheet, where?
It is not mentioned in the prayer portion, but.
So it is
mentioned in the-
understood. Not mentioned. We will not understand. You have to clearly pray, make a prayer. Can't grant unless you pray. There is no prayer. Nowhere mentioned. Only in the category of code you have mentioned. Year number. Then council, you have to make a prayer. You have to pray, specifically pray for quashing of the charge sheet, GR case, taken cognizance if there is no prayer. No. No, Lord Council, we can consider, but we will not consider. You have to learn. You have to amend this. We'll pass order tomorrow. You have to amend, make a prayer. Is there any prayer?
No, sir.
You have a pray. You have to pray. You amend the prayer. We'll consider. Okay. Ask some senior or see the old petition also when you draft. If there is no senior, you see the old petition. You are who is your senior?
Tito po.
Okay. No, so, Mr.
El Kagong.
Land Council for the petitioner. Some states inadvertently there is no prayer for setting aside and quashing of the impugn, the quashing of the proceeding. Pending before. The which court it is pending?
It is in JMFC UPI.
You have to mention that also. Nowhere mentioned. Pending and proceeding before the judicial magistrate first class. Therefore, he prays that he may be allowed to amend the prayer. The prayer is allowed. List is when? When do you want?
Day after tomorrow.
Day after tomorrow.
Yes.
Okay, list is, and the prayer is allowed. List is matter. Day after tomorrow. Give the date, huh? Okay.
Obliged.
Item number 5.
May it please your lordship.
Mhm.
Lordship, this is an application for quashment of the FIR. It's an FIR dated 26 November 2020. Lordship will find it at page 20. If my lord comes to page 20.
Yes.
I'll read the FIR. With due respect and humble, the date Lordship will see towards the top, just below the address portion, 25th November. The date, my lord, just below the address portion, address to the officer in
Yes,
charge.
yes. Yes, yes.
25th
2020.
November. Yes, my lord, 2020. FIR against so-and-so. With due respect and humble submission, I beg to state that since 2 months, I have conversation with Mr. Bijay Sharma from Udalguri, Assam through phone for Falkland earth excavator deals. In that way, both have become friends and I trusted him. Meanwhile, he promised me to provide a Falkland, for which he asked me to send a token money of rupees 30,000. Accordingly, I sent the money on 4th September 2020 through Central Bank of India, account number so-and-so, in the name of Neha Devi, his daughter, branch Azhara. It is surrounded by Borjar and Jalukbari localities on northwestern part of Guwahati, Assam. Again, on date 6th, rupees 80,000 has been credited to her account. Again, on 7th September 2020, I sent him another 1 lakh credited in her account. And 14th September, a sum of rupees 50,000 positively. Total money I paid him through his daughter's account number, a sum of rupees 2,60,000 in 4 installments. After the transaction, I was waited to receive the Falkland at Holongi check gate at the time and date given by him, but the Falkland never arrived. Several times I called him and he will say that it is on his way to Itanagar. He mentioned several stations covered. He told me due to insurance failure, MVI caught the Falkland, need urgently a sum of rupees 50,000 only to release the Falkland. Even he sent a picture of the Falkland, but he cheated me. Secondly, he promised me to pay back the money after he sold out his land. He also promised to return the money. He says customer is ready to buy, only need a surveyor who is making late, and that was also failure. Another assurance he made was he was doing a contract work at Alipurdwar, after which I will get bill, I will give back the money. Even more I took from you. So many promises made, but all became failure. Till today, he could not pay back the money. I believed him. He turned out to be a cheater. I told him, if you go on lying, I'll go to the police and lodge complaint against you. But he requested me not to do. I'll pay you back very soon. In that way, I waited for almost 3 months now, but no development. Bijay Sharma can be reached on his mobile number so-and-so and is still active. If he is without reach, his daughter Neha Devi, which is account number I sent the money, can be easily traced out and nab the culprit Bijay Sharma, and his wife Sabita Devi, account number so-and-so, branch so-and-so, Pandupur, Guwahati. Therefore, Your Honor, FIR is being lodged and this case is to be registered here in Itanagar police station to bring the culprit Bijay Sharma to Itanagar police station immediately. Heard that Kosubari Habi Udalguri is his village and he stays in Guwahati. He can be easily traced out to the bank details of his daughter and wife. From the facts and circumstances of the case, that the accused person's intention to cheat was from the very beginning of the deal.
There is also private respondent, it appears.
My lord, the informant, the FIR informant.
There's private. What happened? It was registered.
It was registered, my lord, in 2020. The notice, if my lord turns to the next page, at page 21, the notice was sent this year, my lord, on 21st of May 2026, after 6 years. And that was the COVID period during which, my lord, the money was sent. And in fact, I have stated, my lord, in my paragraphs at para 10 and 11 at page 8, that I had contacted, I received the money in my daughter's account. I had contacted one Mr. Rohit Singh of Siliguri, and I had paid that entire money to Rohit Singh, but he did not give the Falkland. That is, I have categorically stated in para 10 and 11. And in fact, I have returned, my lord, rupees 80,000 to the informant. This I have stated at para 11, at page 8. My lord, this is a pure civil transaction.
Is there any document to show that you have paid?
My lord, when I came to the police station on the 31st of May, I had paid him 80,000. That was all I could manage, my lord, because the money I have already paid to Rohit Singh. I had paid to him in cash. I had withdrawn the money. But my lord, another aspect, my lord, for 6 years, they do not do anything because they know it is a civil matter. It's a pure civil transaction. There was no intention to cheat. And my lord, the notice at page 21, Lordship will see this is a notice under section 35 BNSS. The FIR is registered under IPC. Under the CRPC, my lord, section 420 IPC, it has been registered. But they send this notice under BNSS. This cannot be done.
What is wrong in it?
My lord, it has to be sent under
notice sent after
but the
this
information has
BNS came into being, and then the offense occurred before the
before
BNS.
BNSS. This FIR was registered before BNSS in 2020 itself.
No, notice has to go under BNS only.
No, my lord, under CRPC.
BNSS only.
No, my lord, I'm sorry, my lord. It has to go under CRPC because the investigation continued from the date of FIR. There is no trial. But the information was registered under.
I think we need to,
My lord,
need to confirm, see,
my lord.
because the notice will be issuing only
Right.
after implementation
Yes, my lord.
of the BNSS.
Yes, my lord. But if my lord comes to BNSS, the section, my lord.
That the case, if registered earlier, will go
Yes.
under BNS. But
Under
then now
CRPC.
the procedure will be, have to be follow BNSS only.
My lord, if I'm not
And then-
mistaken, my lord, the
Yes,
investigation.
the
has
case
to
was
be
registered under IPC. It will go under IPC only.
Under IPC.
But then the procedure has to follow BNSS only.
My lord, after the charge sheet is filed. After charge sheet
Charge
is
sheet already filed.
No, my
Charge sheet
lord.
filed under which? Huh?
My lord, no, it has not been filed. I have been called on 31st of May 2026, my lord.
Charge sheet not yet filed.
Not yet filed. The trial has to be under BNSS, but the investigation has to continue under CRPC. My lord, this is one aspect of the matter. But the more important aspect, this is the procedural aspect. But the more important aspect, my lord will see from the tone and tenor of the FIR. This is one
Anyway.
aspect of the matter, but from the tone and tenor of the FIR, he knows where I am. My Aadhaar card and PAN card are also with him. Had there been any intention to cheat, my lord, why would I have taken the money in my daughter's account? Of course, here there are two petitioners because both the father and the daughter have been named as accused. And my lord, both of us are petitioners here. But in the daughter's account, if the money is to be taken, the entire allegation is against P1. Against accused number 1, my lord, Bijay Sharma.
Since there is private respondent also, will issue notice?
My lord, for the time being, my lord.
Mr.
And
P.T.
call for
Land
case diary also, Lordship. Call for the case diary also.
Okay,
Under
assisted by,
invest-
you are assisted by?
Mr. S. Rana, my lord.
Yes, Rana. Land Council appear for the petitioner. Also heard Miss L. Hage, Land additional PP for the state. Start on para. This application under section 528 of the Bharatiya Nagrik Suraksha Sanhita 2023 has been filed, praying for quashing of the FIR in Itanagar PS case number 276/2020 under section 420 of the Indian Penal Code 1860 Stapa. The Land Council for the petitioner submits the allegation is transferred from the FIR is purely civil in nature. Okay, Papa. Press para. Issue notice. Call for the scan copy of the case diary.
Yes, Lordship.
Okay. Stop.
Okay, updated case diary, Lordship, because it's under investigation, Lordship. It is.
Yes. Case diary. We'll call for the case diary. Stop. Okay, list this matter.
My lord.
When?
After vacation, my lord.
After vacation. Okay.
Could it be on 4th of August, my lord? Or because I heard, my lord, the first 2 weeks, lordship, the bench will be busy.
4th August. Okay.
My lord, I have an interim prayer, my lord.
What interim prayer?
My lord, that the investigation, my lord, be not proceeded with at the moment, my lord.
No, proceeding we will not be able to stay.
My lord,
Proceeding. Let the investigation proceed. But then if you are praying for, have you applied for, if you, are you apprehending your arrest?
My lord, yes,
Or
but
can make a
my lord, no coercive.
an application for pre-arrest bail, seeking pre-arrest bail.
My lord, I have not filed as of now, my lord, because I was under the impression that if the proceeding is stayed, there would be no requirement.
Proceeding, let it proceed.
My lord, then no coercive action may be taken against me, my lord.
I mean, in the meantime. Okay, the counsel for the petitioner further submits that the police, the IO of the case has issued notice upon the petitioner under section 35 within bracket 3 of BNSS. Start para. Well, that is in the above, huh? Okay. In the last then, in the meantime, till the next returnable date, no coercive action shall be taken against the petitioner. Okay. There it appears that the civil
Must be
nature.
carried on, Lordship. Investigation must be carried on. Lordship.
However, no, that is enough only. We are not staying the investigation. Okay.
My lord, it will be petitioners, my lord, plural, two petitioners.
Two petitioners?
Two petitions, my lord. The father and daughter both.
Okay.
My
In chart S, in both petitioners, huh?
My lord, my lord. I'm deeply obliged, my lord. Deeply obliged.
Item number 6.
May I please submit, my lord?
Yes.
My lord, this criminal revision petition was filed assailing the legality and validity of the order of the learned session judge UPIA dated 3/11/2023.
Yes.
My lord, in the last occasion, the legal aid counsel was appointed.
Yes.
If she is ready to argue, then we can proceed with the hearing.
Yes. Can we go? Okay. Yes.
All right, man. My lord, the brief background of the case is, my lord, the criminal machinery was set into motion by a written FIR received from Sri Sama Dodum on dated 6/1/2019 at around 1 a.m. That his wife Srimati Maya Dodum received a call from their son-in-law Sri Narbia Pangia, husband of the deceased victim and one of the alleged accused person, informing that their daughter, late Lakshmi Dodum, had committed suicide by hanging herself. A suicide note was also recovered, wherein the deceased had stated that she could not continue living any longer as she had lost his love and affection to someone else. On receipt of the same, Itanagar Women Police case number such and such was registered. That after the completion of the investigation, the IO found a prima facie case under section 306, 120 under bracket B and 34 IPC and submitted the charge sheet.
So where is the FIR? Let us just see once.
FIR, my lord, Annexure 1. Oh, no, sorry, my lord. FIR is Annexure 3.
Page
number. It starts from page number 22.
24, okay.
And 24 is the written FIR. FIR was submitted by the father of the deceased victim. May I read, my lord?
Oh, yes. Where is the
My lord.
note?
Suicide note, page number 25 is the handwritten one, 26, 25 to 20, 27 is the type copy. In the suicide note, my name is not reflected.
And then charge sheet filed
Yes, my lord. After
Against
hearing
you
the
also?
parties,
Hmm?
my lord.
against you also.
Yes, I am the alleged girlfriend. I am the one of the co-accused, and one section 120B criminal conspiracy was dropped.
That was dropped.
Yes,
Then what is
306 and
against you?
34 IPC was retained,
Hmm?
my lord.
One,
30
okay, 306.
Yes,
120B
Abatement of
is also there.
suicide.
120B is also there.
That was the of the charge sheet in the charge sheet of the IO.
Okay,
But
that
that was
charge
dropped
file thereafter.
yes, after the
Let
charges
us
were.
see where is that order.
That order, my lord, is that is the impugn order which I've challenged, which is at
Okay, let us see the impugn order.
impugn order is at annexure 1, my lord. Page number.
is more important.
Yes, yes.
Hmm.
Page number 13.
13.
Yes, my lord.
Okay, this is long order.
Yes, my lord. These are our submissions, which I will reiterate here also. But important thing is where my lord come. My lord may peruse page number 17, last line, last paragraph, page number 17, operating portion.
Okay.
May I read, my lord?
Mr. Jamu?
Yes, my.
We'll just take a break of this 4 minutes.
All right, my lord. My lord.
Yes.
My lord, I was referring to page number 18 of the impugn order.
Yes.
Page number 18, the second paragraph, where the learned session judge has framed the charges. May I read, my lord? The second paragraph, just below the last sentence. In the premises aforesaid, after hearing both the learned counsels and perusing the case records as submitted by the police under section 173 CRPC, this court is of firm opinion that the accused persons did abet the victim to commit suicide by causing her mental harassment. The accused Narba Pangia, being a married man, was keeping illicit relationship with the co-accused Yagam Jamo, that is the petitioner herein. And the co-accused, having knowledge of the accused Narba Pangia being married, kept the illicit relation, resulting in death of the victim by committing suicide due to mental torture. Hence, there are strong grounds for presuming that the accused person have abetted the offense in Ms. Yagam Jamo alias Hatung Jamor charge under section 306(34) of the IPC. On being read over and explained the charges, the accused persons so-and-so pleaded not guilty and claimed to be tried. So thereafter, now the trial is at the stage of evidence of the prosecution witnesses. Annexure 2 at page number 20 are the charge with heads. And the section 120B has been dropped. Page number 20, Annexure 2. So during the framing of charges, my lord, our argument was always that just being the petitioner being an alleged girlfriend of the husband of the deceased, does it constitute abetment of suicide? And just being showing that there was a mental harassment, does it also constitute an ingredient under section 306 of the IPC? That has been our grounds of challenge and our argument in the learned session.
Any of the witnesses had stated anything about?
Yes, my lord. I will also come to that, my lord. All the prosecution relied on the statement of 8 witnesses, including family and friends. So, my lord, may I take your lordship to page number 33? The statement of the father, who is also the informant, being represented by the legal aid counsel here in the petition. Well, page number 33 is the statement of Sri Sama Dodum, the father of the deceased victim. My lord, here in the statement, nowhere it shows any mental harassment of the petitioner. Or more so, my lord, coming to Ketana of judgment, my lord, what I have perceived from the legal backgrounds that a person committing suicide and to involve the mental cruelty or mental harassment ingredient under 306, it has to be seen from perspective of individuals and the backgrounds and stature of what their backgrounds were. So, my lord, in these statements, the father also said, my daughter was very matured girl. She was talented and bright as a student. We always wanted this focus on her studies, but she got married to Narba Pangia. She was never that type of weak person who would take such a step. So this is one of the statement of the father, that the deceased victim was never of a fragile mind. Thereafter, my lord, the next is the statements, and thereafter, my lord, page number 36 is the this is the co-accused. We can see the statements of the mother as well as the sisters and the friends of the deceased victim.
Who among these have implicated the accused applicant?
Yes, the informant on his FIR.
In his FIR?
Yes, because there was alleged relationship.
Okay,
illicit relationship.
Based on the suicide note.
Based on the suicide note, but in the suicide note, my name is not there. Only said that the deceased victim only reflected that you being my husband has lost your love for me. So that is why I am taking this drastic step. The statement of all this 161 statement of all these prosecution witnesses also, my lord, then nowhere that it has been reflected that the deceased victim was of a weak and fragile mind to take such drastic steps. More so, my lord, the main ingredient to attract the section 306 IPC is that the involvement of the accused has to be in direct proximate, the cause of proximate positive action has to be in direct, in a connection with the positive action has to be in direct proximate connection with at the time of the occurrence of the said event. So there is no direct connection of the alleged co-accused, that is the petitioner herein. There's a judgment I have relied during my argument at the learned session judge also, my lord.
So according to you, the statement,
My lord, the statement
who
is the-
implicated, you said?
my lord,
Who implicated the accused in their statement? Informant.
my lord, yes, the informant, the father of the victim.
You have annexed.
Yes, all the statement, TCR is also there, my lord.
Okay.
Written
Who
FIR.
else? Father?
Father has implicated me as well as my lord.
Mother also?
My lord, I have to see again, my lord, it's the statement of the mother, I have to check. Statement of the mother is at page number 22 of page number 46. Srimati Meya Dodum.
Father is at page?
The mother has not implicated me. My name is not there in her.
Oh, no. No, who
Sorry,
has
sorry, my lord. It's
implicated?
there.
Who has-
Relationship.
It's there.
Yes. Father, mother, Srimati
Father is
Meya.
at page?
Statement of the father.
Mm-hmm.
Statement of the father is at page number 33.
Mother at,
Page number 46.
and who else?
And
Page 33. Father says. She took your name.
yes, the
Father.
father has
Okay.
stated
Okay.
that I was in relationship with his son-in-law.
Hmm. Okay.
And there is a friend, page number 43. Miss Ringu Jiri, 25 years old. She was a friend of the deceased victim. She did
Mother,
not mention
page-
my name, but she was aware of the relationship of his illicit relationship of his friend's husband. Page number 43 of my petition. But my lord, what is
She's a friend.
she is a friend, independent witness,
Friend of?
the deceased victim.
Hmm.
My lord, what is important in her statement is at the last line after but.
Where? She was not.
Page number 40. Yes, she was not that type of person who will take such a step. These are substantial ground to show that the deceased victim was not of such of a weak mind that just because there was an illicit relation to take such drastic step of suicide. And after that, page number 44. This is also, I believe, a friend, yes, independent witness. There also in her last
Yes,
line.
Sam.
Yes, she was not a weak girl who will take such a step. Thereafter, Miss Yari Dodum is a younger sister. Page number 45.
What she stated?
She stated my name. She implicated me that I was in a relationship with the husband. She is the sister of that victim. These are
Sister.
like interested witness, my lord.
Only relation or any she said
My
that
lord, I
you-
could find I could find only two independent witness. Rest are the statements of family and friends, of only family members, husband and myself. Only these two friends I could, out of the 8 prosecution witnesses I could find out. The rest are all family witnesses.
What else?
So, my lord, my lord knows that the word definition of suicide is not there in the earlier code or in the Sanhita. So, when we see section 306 IPC, we have to we only get the definition of abetment, abetment of a thing, which is sorry, sir.
Change or addition.
So, my lord, if criminal manual, please. My lord, in the new Bharatiya Nyaya Sanhita, it is under section 45. Earlier, it was 107 IPC.
School out.
My lord, what does abetment says is section 45 of Bharatiya Nyaya Sanhita 2023. The same, no change with the earlier code. May I read, my lord?
Just a minute. You are reading BNSS?
BNS. Bharatiya Nyaya
BNS,
Sanhita.
just-
Yes,
just-
section 45.
45.
Corresponding to the earlier section 107 of the Indian Penal Code. Just for the purpose of definition, my lord. Because 306 abetment of suicide, there also abetment has not been defined, but we have to take
Yes.
this, yes, help of section 45 of BNS,
Yeah.
abetment of a thing.
Mhm.
A person abets the doing of a thing who instigate any person to do that thing or engages with one or more other person or persons in any conspiracy for the doing of that thing. If an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing or intentionally aids by any act or illegal omission the doing of that thing. So, my lord, now we have to look at section 306 IPC, which is now under BNS is 108, section 108.
BNS, no? IPC?
BNS, my lord. Same, no change. Once, but the section has only been changed, 108.
No, under BNS, it will be 46 only.
That was definition. Now, abetment of suicide is section
Okay.
108. Yes, my lord. If any person commits suicide, whoever abets the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So now, my case is whether, my lord, whether I can be charged under this abetment of suicide, what is my role as a co-accused? Whether there has been any intention to do that, commit that offense, any ingredient under section 48, that abetment to do a thing, then only this section will attract to me. Section 108 BNS, abetment of suicide. So in order to substantiate my argument, my lord, I have some judgment from the Apex Court as well as the judgment from our own Guwahati High Court.
Yes.
I will place one by one, my lord. My lord, this is a judgment from Mariana Anto Bruno and another was it the Inspector of Police. This 2022 0 Supreme SC 1034. For the sake of brevity of time, my lord, I will read the important paras only. It starts from paragraph 25. Paragraph 24, my lord. My lord has got it. Paragraph 24.
Yes.
Here, my lord, while analyzing the provisions of section 306 IPC along with the definition of abatement under section 107 IPC, a two-judge bench of this court in Geo Varghese versus State of Rajasthan and another 2021 SCC Online SC 873 has observed as under. In our country, while suicide in itself is not an offense as a person committing suicide goes beyond the reach of law, but an attempt to suicide is considered to be an offense under section 309 IPC. The abatement of suicide by anybody is also an offense under section 306 IPC. It would be relevant to set out section 306 of the IPC, which read as we've already read. Thereafter, at under para 14, though the IPC does not define the word suicide, but the ordinary dictionary meaning of suicide is self-killing. The word is derived from a modern Latin word suicidum, but su means oneself and sidum means killing. Thus, the word suicide implies an act of self-killing. In other words, an act of death must be committed by the deceased himself, irrespective of the means adopted by him in achieving the object of killing himself. Thereafter, my para 25. The ingredients of section 306 IPC have been extensively laid out in M. Arjuna versus State, where the essential ingredients of the offense under 306 IPC are the abatement, number one. Number two, the intention of the accused to aid or instigate or abet the deceased to commit suicide. The act of the accused, however, insulting the deceased by using abusive language will not, by itself, constitute the abatement of suicide. There should be evidence capable of suggesting that the accused intended by such act to instigate the deceased to commit suicide. Unless the ingredients of instigation, abatement to commit suicide are satisfied, accused cannot be convicted under section 306 IPC. Thereafter, para 26 minus. In order to convict an accused under section 306 IPC, the state of mind to commit a particular crime must be visible with regard to determining the culpability. With regard to the same, a two-judge bench of this court in Uday Singh and others versus State of Haryana observe as under. In cases of alleged abatement of suicide, there must be a proof of direct or indirect acts of incitement to the commission of suicide. It could hardly be disputed that the question of cause of a suicide, particularly in the context of an offense of abatement of suicide, remains a vexed one, involving multifaceted and complex attributes of human behavior and responses, reactions. In the case of accusation for abatement of suicide, the court would be looking for cogent and convincing proof of the acts of incitement to the commission of suicide. In the case of suicide, mere allegation of harassment of the deceased by another person would not suffice unless there be such action on the part of the accused which compels the person to commit suicide. And such an offending action ought to be proximate to the time of the occurrence. Whether a person has abated in the commission of suicide by another or not could only be gathered from the facts and circumstances of each case. My lord, thereafter, I have paragraph 34. Para 34.
Yes.
A bare perusal of the impugned judgment indicates that the High Court erred in recording the finding that there is a sufficient evidence for convicting the appellants under section 306 IPC, losing sight of the fact that there exists no evidence on record indicating that deceased was meted out with harassment by the appellant just before her death. It is well settled that not only there has to be evidence of continuous harassment, but there should be cogent evidence to establish a positive action by the accused, which should more or less be proximate to the time of occurrence, which action can say to have led or compelled the person to commit suicide. Para number 36. To convict a person under section 306 IPC, there has to be clear mens rea to commit offense. It also requires an active act or direct act which leads the deceased to commit suicide, finding no other option, and the act must be such reflecting intention of the accused to push deceased into such a position that he commits suicide. The prosecution has to establish beyond reasonable doubt that the deceased committed suicide and appellant number 1 evaded the commission of the suicide of the deceased. In the present case, both the elements are absent. Para 38. The court has time and again reiterated that before convicting an accused under section 306 IPC, the court must scrupulously examine the facts and circumstances of the case and also assess the evidence adduced before it in order to find out whether cruelty and harassment meted out to the victim had left the victim with no other alternative but to put an end to her life. It is also to be borne in mind that in cases of alleged abetment of suicide, there must be proof of direct or indirect acts of incitement to the commission of suicide. Merely on the allegation of harassment without there being any positive action proximate to the time of occurrence on the part of the accused, which led or compelled the person to commit suicide, conviction in terms of 306 IPC is not sustainable. Thereafter, para 42. It says it is well stated that the courts ought to be extremely careful in assessing the facts and circumstances of each case and the evidence adduced in the trial for the purpose of finding whether the cruelty meted out to the victim had in fact induced her to end the life of committing suicide. My lord, this was after the trial was done, this judgment. But there are judgment, my lord, which are, I like to place another judgment. This I relied during the argument in the framing of charges. This judgment I relied. Thereafter, my lord, judgment of our own Guwahati High Court, two judgment I would like to rely. This the first judgment of our own High Court decided on 29/2/2024. This was delivered by Justice A.D. Chaudhary. This Poonam Uttam Patil versus the state of AP and another. Important point was marital discord and allegation of harassment do not constitute abetment of suicide under section 306 IPC without evidence or instigation or direct action lead to. My lord, even this petition was filed for quashing under 482, and the same was filed after the FIR was thereafter quashed. Here, my lord, the important paras I'm relying upon is para 11. It talks about the ingredient of section 306, para 20. My lord, I have to read para 20 because this factor similar to my this instant petition. May I read para 20? From the aforesaid point of view and the material, leads this court to take an unhesitant view that there is nothing in the aforesaid material which suggests an instigation, provocation, insight capable of leading to consequence of commission of suicide. From the aforesaid material, though it is clear that there were marital discord between the husband and wife on the issue of keeping the wife at the place of posting of the deceased husband, his alcohol abuse, and for some financial demand. However, in the considered opinion of this court, the materials collected, even if it is taken in its face value and treated to be correct, it cannot be said that the accused person had, by their act or omission or by continued course of conduct, created such a circumstance that the deceased was left with no other option except to commit suicide. Such marital discord cannot be said to be an instigation to commit suicide. Rather, materials are available on record suggesting that the wife was staying with the deceased husband at the place of posting in the month of September 2019, so and so period. The deceased allegedly physically assaulted the accused wife in an intoxicated state and thereafter on such and such date for the reason of aggressive behavior post-intoxication. The deceased was transferred for psychiatric evaluation to a hospital and he was discharged and was shifted to unit lines, his quarter, he committed suicide. So, my lord, in my case also, at that period of time, at the uneventful night, the husband and wife were in the same room. Para 21 says, in the totality of the matter and taking all the materials available on record to be correct, this court do not find any active act or direct act on the part of the accused persons, which led the deceased to commit suicide, and this court from the aforesaid material do not find anything which suggests that the accused person by their action have intended to push the deceased into such a position that he committed suicide. The mere allegation of harassment and marital discord, demand to stay with the husband at this place of posting, demand to acquire property for the husband and wife, without there being any material suggesting any positive action proximate to the time of occurrence on the part of the accused person, which led or compelled the person to commit suicide, in the considered opinion of this, cannot constitute an offense under Section 306 IPC. Thereafter, my lord, that FIR and all the charge sheet were quashed. The other my lord, the other judgment from this our own Honorable Guwahati High Court is delivered by Honorable Mr. Justice Anjan Muni.
Yes. Enough, I think that is.
My lord, I have to place this judgment also, and there was a recent judgment of the Supreme Court also. My lord, then I will only put the paragraphs. I will not take much time of this Honorable Court. My lord,
Sarah?
My lord, this is Hussain Mohammad Rizwan versus the State of Assam. This is decided on 15/12/2025. The relevant para 22, 21, 20, para 20, 21, 22, 23, 25, 26 up to 30. From para 20 to paragraph 30, my lord. Thereafter, my lord, the recent Supreme Court judgment where I am relying is.
So from this paragraph, which one is relevant?
My lord, this all talks about the ingredients as well as mental cruelty, mental harassment, which ought to be taken into consideration from person to individual perspective, all these things, my lord. And whether the marital discord comes under the ingredient of abatement. My lord, this recent judgment of Balaji Jaiswal versus State of Chhattisgarh and another. This is 2026 Supreme SC 406. I will not take much time, my lord. Here also.
Is it different? Is it different? Same.
Same, my lord. But
Then
my lord,
it's okay, fine.
My lord, I'm on merit. So my lord, I need, if there is any mistake, then again we have to face the whole trial, my lord. So my lord, in here, this one, this is 2026 Supreme SC 406, Balaji Jaiswal, my lord, paragraph 10 to 15. Para 10 to 15, my lord. So my lord, to summarize my submission, my lord, only on the implication of mental cruelty, I've been made a co-accused. So my lord, to conclude my argument on that basis, my lord, for the concept of mental cruelty depends upon the milieu and strata from which the person comes from, and definitely has an individualistic perception regard being had to one's endurance and sensitivity, my lord, one's background. He has to see the endurance and sensitivity of the person who has committed suicide. It is difficult to generalize, but certainly it can be appreciated in a set of established facts. Extramarital relationship per se would be an immoral act. However, other ingredients are to be brought home so that it will constitute a criminal offense.
Which
my
paragraph you're reading?
No, my lord, this is my own submission, my
Okay.
lord, not from the judgment. So, my lord, it is respectfully submitted that each suicide is a personal tragedy that prematurely takes the life of an individual and has a continuing ripple effect, dramatically affecting the lives of families, friends, and communities. However, the court of law, while adjudicating such cases, is not to be guided by emotions of sentiments, but the dictum is required to be based on analysis of facts and evidence on record. So, my lord, that's all my humble submission, my lord. Highly obliged.
Yes.
Lordship, first of all, Lordship, what's wrong in this impugn order, Lordship, which is passed in 3/11/23, Lordship? This is the Lordship introductory order. This is not a final order, Lordship. And Lordship, moreover, Lordship, in this order, Lordship, the next date is fixed on 21/3/24 for evidence. That means, Lordship, this proceeding is still going on. And Lordship, the trial has not been yet completed.
Yes.
And Lordship, moreover, Lordship, under section 397, Lordship,
What is the, by the way, what is the stage of trial now?
Prosecution witness, my lord.
How many of?
Almost, yes, prosecution witnesses. I have to check. Last time it was up to 4 or 5 witnesses has been examined, my lord.
You have annexed this,
Only the
the
statement.
statement is, the police statement,
Yes, my lord.
not the deposition.
Yes, because it,
How many have already been examined?
my lord, I've heard up PW 3 or 4. My lord, I have to.
Is it updated case, trial court record?
no, Lordship, it is not updated, Lordship. And Lordship, moreover,
Now, when this was called for? When this was?
this is long before, Lordship. Somewhere in the year 2024, Lordship.
Which court?
Session Judge
Session-
UPA, my lord.
This is 2024.
Yes, Lordship. Lordship,
I
they have
think-
only challenged the impugn order, Lordship. And Lordship, impugn order, what's the wrong in the impugn order?
No. So because impugn to consider, because according to him, there is no prima facie against him.
Lordship,
There
impugn
is
order,
no abatement on the part of the present accused.
Lordship, if you go
That is,
to
the charge cannot be framed. His prayer is.
Lordship, yes,
Yes,
Lordship, if
He
you
is challenging the charge framed against her.
Rightly, my lord.
Lordship, if you go to the merit of the case, Lordship, then Lordship,
I'm on merit
there is-
only, my lord.
yes,
No.
Lordship,
Hmm.
there is Lordship, prima facie, Lordship. That's why Lordship, the impugn order passed, and that is the Lordship.
No. So
On next-
his submission, probably his petition is challenging the charge framed against the present accused person,
Yes, Lordship.
saying that no charge can be framed. It will be an unnecessary harassment because there is no prima facie case against.
Yes, Lordship.
Although she was she had an illicit relationship with her husband, but it doesn't mean that she has abetted
Yes, Lordship.
the commission of suicide. That is why he is praying for the.
Rightly, my lord.
Now, Lordship, this proceeding is going on, Lordship. Now,
We need to know the present status,
Lordship.
actually. I thought this statement is before the deposition. This is
My
police
lord, this has
statement
been
only.
pending because
Ah.
at the time of filing, the trial was not commenced. 2024.
Could have called for the actual updated, because the trial was not stayed.
Yes. I never, although I had an interim prayer,
Ah.
but I never pressed for the interim because already
it
it
was
was so
never been
long.
considered, Lordship. Interim was never been considered because the Lordship, due to the Lordship, the
No, now at this stage,
seriousness
the
of the-
interim also cannot be considered, but
Yes,
an entire matter can.
I understand, my
But-
lord.
But for consideration, since the trial of the case has substantially
Yes, my lord.
properly
Yes.
progressed,
Yes.
so need the status present, because you are based on the police statement.
Yes,
Now, since then, they have given a deposition.
my lord. That
Statement,
can be called for, my
ah.
lord. But my submission
I
may
thought
be
of this. Okay.
recorded and all this
I
judgment.
thought the record is updated.
yes, Lordship.
That can be called for, my lord.
No, then. It will be, then it will again
Can
take
it be
time.
called on Friday, my lord?
Friday, is it possible?
Lordship,
Day after
we'll-
tomorrow.
We'll take a chance because nearby.
Scan
Lordship.
copy at least.
Okay. No. Okay. Because you are, when there is a deposition already, the prosecution has already been examined. Why should you base on the police statement?
My lord.
Okay, Mr. Skijamo, Learned Counsel for the petitioner, also heard Ms. L. Hage Learned additional PP for the state and Ms. Intigera for Learned Counsel appearing on behalf of the private respondent number 2 staff. At this stage, sorry, Ms. L. Hage, Learned Counsel for during the course of the hearing, Ms. L. Hage, Learned additional PP submitted. The record is of 2024. There are 2024, and since there is no stay in the no stay of the proceeding of the trial, the prosecution witnesses has already been examined. So, in view of the above, she submitted and examined, and the record updated trial court record would be necessary for proper adjudication of this case. Stop. In view of the above, call for the updated trial court record. Rest are otherwise available except the deposition.
Yes.
The updated Lordship.
You just inform, otherwise the rest of the document you have.
Yeah.
The updated one thereafter, after 2024. The progress. That would be only the deposition of.
Only the
witnesses.
deposition, yes,
Okay.
my lord.
You can ask for.
Date for Lordship through the registry Lordship.
Okay.
We call for Lordship.
Scan copy maybe.
In view of the above, call for the updated trial court record, scan copy of the trial court record. So, let's pray for list this matter again on
Friday?
Friday.
3rd Lordship. 3rd of July, Lordship.
3rd of July is Friday.
3rd of July. Okay.
Yeah.
We'll
Highly
see.
obliged, my lord.
Obliged Lordship.
Item number 7.
Yes.
Lordship, in this case, I have filed Ukalatama on behalf of respondent number 2.
You are for respondent number 2 appearing for the first time.
Yes, my lord.
This is, what is this case about? Criminal
It's a criminal petition, Your Honor.
criminal petition.
Yes, Your
Your
Honor.
Lordship, kindly look at the order dated first order, 30th July 2025. Particularly para number 7, my lord. The petitioner was asked to take the steps within 3 days from that day, my lord. Until today, almost 1 year has passed. They have not taken the steps as yet. Your Lordship, kindly go through the office note also.
Not yet taken, not yet taken. Why? After?
We came to know about the existence of this particular petition only on the other day when the IO has deposed in the election petition, my lord.
What happened? Because the proceeding was not stayed.
There is an interim order, no coercive action should be
No
taken.
coercive, but then the proceeding not stayed. Proceeding in respect of the other accused person shall continue as usual.
And on the basis of this stay order, they are not filing the search sheet, my lord. But the other day, the IO has deposed in the election petition, and he has informed that because of the stay order, he has to send the search sheet to the legal department, and legal department has given the veto not to file the search sheet because of this stay order, my lord. Only then we came to know about the existence of this present case, my lord. And till date, the petitioner has not taken the steps, my lord. That is the status of the case as of now. Let them issue an furnish copy of the petition, my lord, and let the interim order be vacated, my lord.
Uh, Your Honor, will issue notice, but stay cannot be vacated.
There are two FIR. Third, huh?
Yes.
This is third.
There was an FIR
What happened to that two FIR? Registered already? Investigation
completed, my lord.
completed? Charge sheet filed?
Charge sheet filed.
Okay, so this is with regard to the same.
That is a query which I've asked to the department, madam. So.
No, this is not this particular affair is for a different aspect, my lord.
But then.
That is a completely different case, my lord. Certain fake documents were submitted to the bank, and on the basis of those documents, he has obtained a loan, my lord.
It says that covers within the amount at least in the first FIR. Illegal loan.
All the instances are different, my lord. Different loans amounts were disbursed to different persons, my lord. We concerned with only one particular FIR, my lord.
So it's only no coercive action. The proceeding was not stayed.
Yes, my lord. But even after that, they have not filed a search sheet, my lord. And because the other day, what the IO has deposed, my lord.
See,
Yes,
the
sir.
recording of examining the accused, examining any witnesses was not prevented.
No. Only.
Then what prevented the police to filing charge sheet?
No, no. 2016, there was an FIR, my lord. And the FIR alleged that there was misappropriation of 71 crores, madam. Now, again, in 2018, an FIR was filed, madam. Both those FIRs were kept together, madam. It made one, madam. Thereafter, this complaint came in, madam. But this also pertains to that same.
Same. So in that case, whether the accused has been arrested,
Yeah, they were arrested.
the applicant, the petitioner.
Arrested and they were released from jail, madam.
Okay, so it will be a double, triple arrest of the accused. That is why probably no coercive action.
Fine.
But according to the land council, you are for
I'm for the respondent number 2 only.
Respondent
the person
number
who has
two is
filed the FIR,
informant.
my lord.
informant.
Informant, my lord.
Informant
present
is,
affair.
who is the informant?
One Mr. Takar Banat.
Authority? No, bank or what?
No, he's a private person, my lord.
Private person?
Yes, my lord. He has filed a FIR to he's lodged the complaint. Subsequently, that was registered as an FIR. Now the investigation is going on, my lord. Allegation is that certain fake documents were given to the.
So according to you, there are more than
Yes, there are.
so this amount is not covered under the earlier
Yes, my lord.
FIR 1 and 2.
Because the
But then the investigating agency would be the right person to know about that.
yeah, they have to state, my lord.
There is
He's
no
a-
arrested, my lord. It
Well,
doesn't depend, man.
let him file
Is the
a
record
affidavit.
produced?
Why should I file an affidavit, my lord?
No, record.
That's why, my lord, my query was to the extent whether this amount the alleged amount, my lord. There may be so many things, my lord. There may be fake document, my lord. But and in accordance with that fake document, my lord, this amount might have been siphoned off, but my particular query is that whether this amount comes under the earlier FIR or not. If it
Okay.
comes under
Whom did you ask?
the department, my lord.
Department. Why did you get the answer?
Therefore, my lord, I have been I got the instruction, my lord.
Okay.
But it's not very clear, my lord. Therefore, I have again.
Get the written instruction.
Yes, madam.
Get the written
Yes,
instruction.
that's what I'm.
Let them say.
My lord.
Let them.
Written, because verbally they will not be able to clearly state.
Yes, ma'am.
On the written, along with the document, if it is possible.
And so for
Okay.
non taking the steps.
Have you
my
received
lord-
the copy now?
No, my lord. They have not yet taken the steps, my lord. Even after 1 year, my lord.
Your Honor, I will furnish the
Okay.
copy to the respondent number 2.
Later furnish the copy today itself, my lord. And in the meantime, the stay order may be vacated, my lord.
No, the stay.
Third, Miss
M. Jara,
Learning
the
Council
petitioner.
appearing on behalf of. Your name is also there?
Yes, Your Honor.
Okay. For the petitioner. The record reveals the office note dated 12/2/2026, 8/5/2026, and uh, 8/5/2026 reflect that the petitioner has not taken steps upon the respondent number 2. Stop. How many respondents are there?
Only 2, my lord.
Okay, 2. Hmm. However, today, Mr. I forgot your name.
R. Sekar, my lord.
R. Sekhar, Learning Council, who appeared on behalf of the respondent number 2 by filing Wakalatnama and submits that you have not received any notice.
No, my lord.
Hmm.
As well, they have not yet taken the steps, my lord.
How you came to know about the?
Because the other day that the IO has deposed in the election petition, my lord.
Hmm?
The other day, the IO who is investigating the case,
Huh.
he has deposed in our election petition. We, that day we
In
came to
what?
know. In the election petition, he has deposed.
Huh.
He was a witness here.
Okay.
And that day he
This is in connection with the election petition.
in connection with the election petition, the IO has deposed, my lord. That day he had told, informed this honorable court that already the investigation is complete and search sheet is ready. But he has sent the search sheet for vetting to the legal department, and because of the stay order given in this particular case, the legal department has asked him not to file the
Who submits that he came to know.
search sheet, my lord.
And the respondent number 2 came to know regarding filing of the present case through some other sources. Stop. Huh? It appears that after obtaining the interim order that no coercive action shall be initiated against the accused, the petitioner deliberately did not take steps for causing of service of notice upon the respondent. In view of the above, the interim order, in view of the above, this court is the court is not inclined to extend the interim order granted to the petitioner, Staff Ankara. the petitioner, since the respondent and the counsel for the respondent number 2 is present, the counsel for the petitioner shall furnish a copy of the petition to him during the course of the day. Start para Mr. O. Pada, Learned Standing Counsel for SCB, submits a praise for further, how much time? Further 2 weeks time to obtain written instruction. Written instruction regarding?
Whether this particular FIR, my lord, comes within the purview of the.
Okay, regarding the question as to whether the present whether the amount alleged in the present FIR comes under the amount covers under the earlier 2 FIR. Okay, or not. Okay. But the such instruction shall be produced before this court by the next date. Okay. Is therefore come this matter after the ensuing summer vacation. Okay.
Awesome.
Oh. Afternoon, the election petition will be taken up. It's be difficult, then rest will be a little bit difficult. Election petition evidence.
Yesterday we have filed
Hmm.
regular second appeal.
Mhm.
So it has come in admission column.
So
Notice-
in the election petition, because afternoon, there is evidence in the election petition.
That's why.
It will take time.
Hmm.
So afternoon, we would like to keep it for the election petition.
Well, I think that case item number 9 simply notice has to go second appeal.
Uh-huh.
Yesterday we have filed. So today this is listed for first time
Uh-huh.
in admission column.
Uh-huh.
So kindly this matter may be
Item number
9, madam.
9. Okay,
9.
9 will take up, huh? 9 will not take up. And what about the others?
Item number 12, your lordship, the TCR is yet to be received. Your lordship.
Okay, item 12, huh? In item 12, council is present.
Yes, yes, present.
Who is the council in item 12?
T. Gatso, your lordship.
Okay, Mr.
I-
Gatsolani, council for the petitioner is present. Ms. Jeannie Learned, additional PP is also present. It's a case diary. The scanned copy-
TCR, your lordship.
TCR, okay, the trial court record is called for.
And-
Is still awaited in view of the above. In view of the above. And as prayed for, come on this matter again,
Immediately after vacation, your lordship.
immediately after
Vacation.
ensuing vacation, ensuing summer vacation. Okay. On which, okay.
Lordship, item number 13, that's regarding the status for the execution of the interim bill. So, execution of the interim bail bond that was fixed today, whether the bill has been executed or not, that status was sought from the PS only.
13,
Yes, that,
what happened? Executed?
yes, executed.
You have a record?
Yes, I have a record.
Who is PP here? Additional PP? Who is for the state here?
Duxer sir was here, but it's executed with, I have a record.
This is regarding what case?
This is regarding criminal
Allegation what?
trespass. Criminal trespass.
Okay.
And
So this 13 also will take up, it won't take much time.
yes,
I'll at 2, okay?
yes,
13 also will take up just
Yes.
because it won't take much time. Oh, what about the 10, 11?
10 may be taken up tomorrow.
Tomorrow, as prayed for by. Okay, Mr. Tungal. Who is for the, okay, as per for by both the Learned Council for the parties. Tomorrow is okay, okay. Release the matter. Release the matter tomorrow. Again, okay. Then 11,
Your Lordship, I'm for the 11.
yes, so
Your Lordship, there's an urgency in this matter.
what is this matter about?
This is about rustication of the petitioners, Your Lordship.
Hmm?
Rustication matter, Your Lordship.
We'll take
Rustication
this
from-
matter also tomorrow. We'll take this matter tomorrow, okay? Release as prayed for by Learned Council for the petitioner, release this matter tomorrow, okay? Because today it will be difficult. Then if 14,
Just quoting the. This is the idea.
Okay. You are protected? No protection. Record was called for?
Anticipated benefit. So this court has directed me to file an additional affidavit.
Okay. Tomorrow then? Okay. As prayed for, comma, by the land council for the petitioner, list this matter again tomorrow. Okay.
Item number 18, this matter may be listed after 3 weeks, Lordship.
18.
Yes, Lordship. With the consent of the other side also.
Okay. Mr. K. Lolan, land council for the petitioner with the consent of the land council for the other side, prays for listing this matter
After 3 weeks.
after 3 weeks. Prayer is allowed. List it accordingly after 3 weeks.
And
Okay.
Or that may be done.
The interim order passed earlier shall continue till the next date of listing. Okay.
Well, item 19, the service report is awaited
Okay.
as per office note dated.
Okay. Mr. S.K. Deru, land council for the petition, applicant is present. The service report in respect of respondent
One
number
and two.
1 and 2 is still awaited in view of the above list this matter after 2 weeks. Okay.
Applied.
Okay.
Item number 16, my lord.
Hmm.
This matter may also be fixed tomorrow, my lord.
Tomorrow? Okay, tomorrow.
Lo-
Tomorrow.
Lodge.
As prayed for by Mr. Picha, B. Picha, land council for the petitioner, list this matter tomorrow again. Okay. Okay. Then we remain 9 and 13, no?
Lodge.
Okay. Yes.
Item number 9,
So, second, notice is to be issued.
This is second appeal, my lord. Invoking section 100 CPC.
Okay.
Here in this case, my lord, the issue is, my lord, whether the outcome of, my lord, the chicken liver test can be considered as admissible as evidence to decide the title of the suit land. That is the only issue. Kindly come to page 58, the impugned order. This is the impugned order that we have put to challenge.
5-8,
Pardon, my lord.
58.
Page 58. Order of First Appellate Court.
This
Civil
order.
Service Senior Division, Dapo Region.
Hmm. This is the impugned order. Oh, no, sorry.
This is the impugned order.
Okay, this order was passed in civil appeal.
Civil appeal, my lord. First appeal. Against the order passed by the village authority.
Where is the order of the village authority?
Kindly come to page 55, my lord. This order, my lord, passed by the village authority, my lord. It seems to be passed by
55.
55, my lord. May I read, my lord?
Yes.
This is passed by one head GB, my lord, head Gambura, village Ragni, Circle Nacho. Judgment and order dated 29 May 2025. The land dispute case Srimati Yaning Kyamdo versus Sri Tache Kyamdo was fixed on 29/5/2024 hearing at Open Darbar under Karungba village. The brief of the case is that the complainant Srimati Yaning Kyamdo was installing BSNL tower in the disputed land. So the respondent Sri Tache Kyamdo protested and restrained the ongoing work, and then complainant made a complaint to the village authority at Ragmi to conduct a kebang as there was no village authority at Karunga village. The hearing of the case was conducted at Nacho on 17 and 18 September 2024. And after going through the hearing from both the parties and examining the independent witness, the Kebang had passed an order in favor of the complainant Srimati Yaning Kamdo. Thereafter, the respondent had challenged the Kebang order by filing a civil appeal before the Honorable Civil Judge Senior Division Daporejo on 18/10/2024 for the jurisdiction of the village authority for hearing the case. As such, after hearing from the respective advocates of both the parties, the Honorable Civil Judge Senior Division Daporejo has remanded the case to the village authority having jurisdiction to hear the matter as per the AFR 1945. This is earlier litigation, my lord. Earlier also we have filed one appeal that was remanded back. Whereas during the pendency of the case, the Deputy Commissioner Daporejo has issued an order dated 24 April 2025 to the Sub-Divisional Officer Nacho for temporary empowerment of Ragmi Village Authority, HGBs and GBs, to assume and discharge the functional powers and responsibility of Korungba Village Authority, HGB and GB. As such, on 29/4/2025, the Sub-Divisional Officer Nacho issued an order wherein the jurisdiction of the village authority, HGB and GB of Ragmi Village, is extended to Korungba Village. After getting the order, judgment passed by the Honorable Civil Judge Senior Division Daporejo, the village authority of Karungba has issued a press parwana to the respondent Sri Tache Kamdo for hearing of the case, again on 16/5/2025. However, the complainant and Kebang members were present, but the respondent Sri Tache Kamdo was absent in the hearing. So the village authority decided to issue a press parwana again to Sri Tache Kamdo for the hearing on 29/5/2025. On 29/5/2025, the complainant is present, the respondent is also present, and all the Kebang members are also present. The attendance of both the parties and Kebang members have been taken. In the hearing, the respondent Sri Tache Kamdo was requested for re-examination of the chicken liver test for settlement of the case. Here comes the problem, my lord. On the other hand, the complainant Srimati Yaning Kamdo has vehemently objected that it is not necessary for re-examination of the chicken liver test. Again, since the examination of the chicken liver test had already been conducted 2 times in 1997 and 2006 in the court of PI political interpreter Nacho, and the result was come out in her favor. Further, after going through the history of the case among Kebang members, the few members are recognized as independent witness in the hearing who were present in the year 1997 and 2006 hearing, namely Sri Tanam Loke Tako Kamdo, Sri Tacha Garam, Sri Tabu Rai, Sri Taba Mari. So these are, my lord, how this conclusion has come, my lord. I never knew. On that day, I was called, my lord. In fact, I was present. No evidence, no statement, nothing was recorded. But then surprisingly, this order comes. And when we have filed the appeal, at least the first appellate court, my lord, should have called for the record also. That has not done. Now kindly see, my lord, the statement of the independent witnesses are hard. And they stated that the present land disputed case has been decided 2 times through a chicken liver test in the year 1997 and 2006 at PI court. The disputed land is belong to the complainant.
So,
in view of the
so decision is based on chicken liver test.
Chicken liver test, my lord.
So for that, these people gathered.
My lord. And kindly see the manner.
No, not to depose, not to give evidence, but to see the chicken liver.
My lord. And kindly see the drafting, my lord. Can it be by one head Gambura, my lord?
No,
down below.
No, they can take assistance of the educated person.
Of course, that is there, my lord.
You cannot expect the Gambura who are illiterate.
How?
But on their instruction.
But then with the above order,
can
the
be
present
reduced into
case is
writing.
disposed of, given under my signature and seal on this 29/5/2025. And it seems, my lord, only one judge, my lord, despite of our objection also, because earlier also this is the same head Gambura who decided the case in favor of respondent.
The complainant is the respondent.
Yes, my lord. In this case, yes.
So view of the submission disclose. What we find someone measures on that. Looking for the respondent.
So accordingly, against this order, we have filed the appeal, that is civil appeal number 7 of 2025.
Good. Okay. What is the decision of the appellate court?
Kindly come to page 65.
Hmm.
Page 65, paragraph 9. Let us see the operative portion.
Hmm.
Para 9.
Hmm.
Further, it appears from the impugned order dated 29/5/2025 that the appellant himself requested the village authority for conducting re-examination of chicken liver test for settlement of the dispute. That is also wrong finding, my lord. Yes, because in the impugned order of village authority itself, it says, in the hearing, the respondent Sri Tache Kyamdo was requested for re-examination of the chicken liver test for settlement of the case. It was not Tache Kyamdo who requested, my lord. It was the head Gambura, the presiding officer, my lord, who requested Tache Kyamdo.
This is regarding land dispute.
Land dispute, my lord. So, my lord, let me continue. But his request was turned down apparently for the reason that chicken liver test was already conducted twice in the year 1997 and 2006, which conclusively decided the suit land in favor of the respondent. And so another chicken liver test was not considered necessary to adjudicate the dispute. Though chicken liver test is not a recognized mode of dispute resolution under Assam Frontier Regulation 1945, but it was the most prevalent and accepted mode of dispute resolution in Tagin community, to which both parties belong. Albeit this practice has now faded under onslaught of modern laws. Such mode of dispute resolution, though not recognized under Assam Frontier Regulation 1945, still assumes significance as the only viable mode in circumstances where material witnesses are either dead or not available, and dispute cannot be otherwise adjudicated properly. The instant case also presents similar situation where no witnesses is available to help the village authority in adjudicating the dispute over the suit land. This appears to be the reason for conducting chicken liver test on 2 occasions in the year 1997 and 2006, which conclusively declared title over the suit land in favor of the respondent. After such adjudication in the year 1997 and 2006, appellant did not challenge the decision before appropriate appellate forum, and he only took up the matter after BSL tower was installed hereon, seemingly to claim compensation. The witnesses, namely Sri Tanam Loke, Sri Toko Kyamdo, Sri Tacha Garam, Sri Tabu Rai, and Sri Taba Mari, who were present during those occasions, were also present in the meeting of the village authorities in which the impugned decision was passed. Their names are reflected in the impugned decision, and they were examined while giving the impugned order. Appellant has not cited any witness who would depose in his favor. So, when material witnesses are not available in a particular case, it is appropriate and justified to rely on primitive method of chicken liver test to decide the dispute. The case would have been different if material witnesses are available and decision was made without examining them. In the present case, witnesses who were present during the resolution of dispute over the lawsuit land through chicken liver test in the year 1997 and 2006 were present in the meeting of the village authority on 29/5/2025, and they were also examined. So it cannot be said that the meeting of the village authority was conducted in violation of Assam Frontier Regulation 1945, as it was conducted in open darbar in presence of the parties and at least 2 witnesses. Hence, there is no apparent error in the proceeding of the village authority which passed the impugned decision, and so the present appeal is without merit and it is liable to be dismissed. Consequently, this appeal dismissed and the impugned decision of the village authority is confirmed. Now, my lord, very interestingly, on 29/5/2025, of course, I appeared, my lord. And what was my submission, my lord? I have said that since the dispute is with relate to the land, wherein if map is seen, my lord, if map is seen east, west, all the boundaries land belong to me. How come in between, in the middle, this respondent, she is claiming the land, wherein she is trying to install a BSL tower? So therefore, I have requested the member present herein, especially to this head Gambura, that spot verification should be there, and the statement evidence of nearby lane owner, my lord.
Okay, what Mr. Tama will do at the moment, will issue notice. Just,
substantial
uh,
of law
no,
has been framed
on
and
the
then-
next date, we'll admit, we'll issue notice at the moment.
my lord. Otherwise, if that
Oh, because what
BSNL
is the,
tower is
what is the
erected,
substantial question, where is,
paragraph 2, page 4, my lord.
page 4?
Page 4. A, B, C, D, E. A, B, C, D, E.
Okay. Okay, today what we'll do, we'll issue just notice.
My lord, if tower is installed, then no meaning of,
Next date, at the time of admission, will stay.
my lord.
If they are after
status
hearing.
quo, my lord, I also, I will not do
Because
anything.
they are claiming that it was decided much earlier, 2007 or what?
1997, 2000.
Oh, 1997,
1997, my lord, it was decided in our favor, in my favor. At that time, this lady, she was not there. Her husband was there.
Mhm.
And 2006 is the case.
Heard Mr. K. Tama, not counsel for the petitioner. Stop. This appeal under section 15. 15(3)
15(3), my lord.
of the Arunachal Pradesh Civil Code Act 2021.
Read with 100.
Mm. This amendment Act 2022
22, my lord.
is amended by the Arunachal Pradesh Civil Codes within bracket Amendment Act 2022. Read with section 100 and order 42. Roman 42, Rule 1 of the Code of Civil Procedure 908 is directed against judgment and order dated 16/6/2026 passed by the Learned Civil Judge Senior Division, Upper Subansiri District, Daporejo, in Civil Appeal number 07/2025, whereby the judgment and order dated 29/5/2025 passed by the Village Authority, Korongba, K-O-R-O-U-N-G-B-A, Korongba Village, Nacho Circle, has been affirmed. Staff issue notice returnable by 4 weeks. Call for the records. Staff, the petitioner shall take steps for service of notice upon the respondents by speed post as well as by usual process within a week from today. Staff, list is matter after 4 weeks. What is your interim prayer?
Kindly come to page, my lord. Page 22, my lord. G, pending disposal of the present second appeal, direct the parties to maintain status quo with regard to the title, possession, nature, and physical character of the disputed land. There are other respondent also, my lord, the BSNL. Otherwise, this second appeal will become in practice, my lord. Till returnable date at least, my lord.
The prayer for interim order shall be considered on the next stage. Staff, Till then, the party shall Till then. It is provided that the parties shall, just a minute. Execution petition they have filed,
No, no, no. They have not filed any execution petition.
the operation. Of the judgment and order dated
29/5.
16/6/20.
29/5/2024.
Okay, 29/5/2025. Shall remain stay. Okay.
Highly obliged. My lord, substantial question of law.
That will next time.
Next,
Let them appear.
because I have come across one judgment wherein
When it is admitted, not yet admitted.
Okay.
At the time of admission,
Ah.
it will be admitted on the substantial question of law next date.
my lord. So meantime only.
No time also.
Highly obliged.
Okay.
Item number 13.
May your lordship,
Yes, sir.
Lordship, on the last occasion, I was directed to
What for?
updated city, Lordship.
Okay, what it says?
whether
Lordship, its CD says, Lordship, his statement was recorded on Lordship.
He was arrested.
Yes, he appeared before the Lordship.
What happened? Whether he was arrested
Yes, Lordship.
and released also
Yes.
based on the
Execution of
interim.
formalities, Lordship.
Okay, well, so whether he's
IO says, Lordship, in.
his custodial interrogation necessary now?
No, not necessarily. IO said that the Lordship, the investigation are almost completed and
Okay,
going to be submitted.
okay. Heard Mr. T. Keeper, Land Counsel for the petitioner. Also heard Mr. D. Loy, Land P. Public Prosecutor for the state, staff para. By an order dated 3/6/2026, the accused applicant was granted interim protection, directing that in the event of his arrest, he shall be released on pre-arrest bail on execution of a bail bond of rupees 30,000 with one surety of like amount, and also directed on the condition, and also directed to appear before the investigating officer within 7 days. Stop. Para. In compliance with the said direction, the accused applicant appeared before the IO of the case on
6 and 22.
6.
6 of 606.
No, 3, Lordship, 3/6.
3/6. The order was passed on 3/6.
Yes, and appeared on 6/06/06.
His statement was recorded on Lordship.
Okay.
Might be 9 on 9.
He appeared before the IO on. So, Lordship.
6.
Yes, 6.
Okay, 6/2026. On his such appearance, the accused applicant was arrested in connection with the New Delhi PS case number 25/2026. And after recording his statement and on completion of the necessary procedure, he was subsequently released on interim anticipatory bail on the strength of the order dated 3/6/2026. Stop. It is para. The Mr. Loy, Lanet PP, on record submits that the investigation of the case has already been almost been completed, and as such, the custodial interrogation of the accused, the custodial remand or interrogation or remand of the accused applicant is no longer required at this stage. Stop. In view of the above, and as In view of the above submission and on perusal of the record, it appears that the accused has already been arrested and subsequently released on bail on 6/6/2026, and as reflected in the case study, his custodial interrogation or remand is no longer required. Stop. Accordingly, the accused, sorry, the interim order, interim anticipatory bail granted to the accused on 3/6/2026 is hereby made absolute on the same terms and condition with subject to the following subject to the following conditions. Okay, just a minute. Have made absolute subject to the following terms and conditions. Stop. That the accused shall continue cooperate and appear before the eye of the case as and when called for. Stop. That he shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case. That that he shall not hamper or tamper with the evidence of the case in any manner. Stop. That he shall not leave the jurisdiction of the Arunachal without prior information to the eye of the case. And the jurisdiction of the Arunachal Pradesh without prior information from the eye of the case. Okay, stop. With the above, this bail application is